All right, this is no application. Are you all ready to proceed?
Yes.
Court is calling 2023 CR 6038, State of Texas versus Richard Gabriel Ramos. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Marshall D. White for Mr. Richard Ramos, the defendant, Your Honor.
And are you Mr. Richard Ramos?
Yes, ma'am.
All right, Mr. Ramos, I'm going to need you to speak up so the court reporter can hear, okay? Counsel, have you received all the discovery in this case and did you review it with your client?
I believe I have it this time, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ramos, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
In a hushed courtroom, the air feels heavy with anticipation. The judge's voice cuts through the silence, calling the case of State of Texas versus Richard Gabriel Ramos. Every word is precise, each question deliberate, probing whether the accused understands the charges against him. Richard's responses are brief, almost swallowed by the tension in the room. The foundation of the trial is being set, and already, the weight of what's to come hangs over every exchange. The question now, will the details in this indictment seal his fate?
Are you proceeding with the enhancement allegation?
Yes, Your Honor. Judge, this is a conflict.
Ah,
Sorry.
no, my fault.
Except by the paperwork.
Mr. Ramos, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of assault of a public servant bodily injury? If the enhancement allegation is proven to be true, that will be a second-degree felony. The range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
The judge wastes no time, laying out the heart of the matter. An assault on a public servant, an allegation carrying the power to turn years of freedom into decades behind bars. The reality is cold and unflinching. 2 to 20 years in prison, a fine that could shatter stability, and a warning that even a plea bargain offers no promises. Richard listens, his fate balanced on understanding every word. Yet the truth of what he's agreeing to has only begun to unfold.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand?
Yes, ma'am.
All right. I'm going to need you to speak up, okay?
Yes, ma'am.
All right.
I just need those papers, okay?
Oh, that's okay. All right. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe he was, Your Honor.
The rights of the accused are read like an oath. The right to a jury trial, the right to confront witnesses, the right to remain silent. Each one, a shield against the weight of the state, is set down in front of him, only to be surrendered. Richard agrees, relinquishing protections that could have been his defense. His lawyer confirms his competency, but behind the formalities, a single question remains. Does giving up these rights lead him toward mercy or toward an unchangeable end?
Mr. Ramos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yeah.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, you agree that you've been previously convicted of a previous felony. Punishment is to be assessed at 7 years in the prison. There are no applications. The state will take in consideration 2023 CR 6039 and 712653. Did you understand that to be the plea?
Yes, ma'am.
The judge's questions pierce deeper now. Has anyone threatened you, coerced you, or made promises beyond the plea? Richard says no. He affirms his satisfaction with his defense, even as the reality of the deal becomes clear: 7 years in prison. Prior convictions are pulled into the light, each one a ghost from the past that now follows him into this moment. The plea is on the record, but what's truly agreed upon is a future already written.
Defense,
Yes, Your Honor.
state,
Yes, Your Honor.
showing you the waiver of appeal paragraph. Mr. Ramos, showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
What was that again, ma'am? Sorry.
All right. Did you understand the waiver of appeal paragraph that you signed? This paragraph where your signature is listed. Did you understand it?
No, can you read it again?
I'm sorry, what?
No, can you read it again?
What did he say?
He said, no, like, can you read it again?
All right.
The formality of law continues. Now, the waiver of appeal. With pen to paper, Richard is told he's giving up the right to challenge whatever sentence is handed down. The judge explains the narrow exceptions, yet confusion flickers across his responses. The stakes here are subtle but severe, because once this right is gone, it is gone for good. And still, there's uncertainty in his voice, leaving the room wondering, does he fully grasp what he's surrendering?
So, first of all, did you sign this?
Oh, yes.
Did you go over it with your attorney?
Yes.
All right. When you sign this, what you're saying is that you are waiving your right to appeal. And waiving your right to appeal is, in layman's terms,
Oh, no, I don't want-
waiving your right to complain about a sentence. Did you understand by signing that you're waiving your right to appeal? Now, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. You understand?
Yes.
Did you understand that?
Well, I didn't understand the appeal, no.
All right, do you understand it now?
Yes, ma'am.
Do you still wish to continue?
Yes, ma'am.
All right.
The meaning of the waiver is laid bare. To give it up is to silence any complaint about the sentence, to shut the door on. Appeal before it can even be considered. Richard admits he didn't fully understand before, but now he does. The judge asks again, and again he agrees to move forward. The moment is small, but its finality echoes. This is the point where choice becomes commitment, and there will be no turning back.
Counsel, have there been any such motions?
No, they have not. But I will just say, Judge, with respect to this, it's the same documents, certification of your right of appeal. It's the same thing. Okay, you understand? The judge goes along with it. You just have no right to appeal. I did explain that to you. Yes. Okay.
All right. Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Contest.
And to the enhancement, how do you plead? True or not true?
The enhancement is a prior conviction.
What do you mean, like the enhancement of?
The prior conviction.
Oh, yeah.
Did you review?
It's a true or not true. Is it true?
It's not true.
It's not.
All right, so I'm going to read it to you and I want you to answer if it's true or not true, okay?
The conversation pivots toward the plea itself. The charges, the enhancement for prior conviction, each must be answered directly. Guilty or not guilty? True or not true? The judge presses for clarity, the legal language narrowing into yes or no. In the space between the questions, the courtroom waits for his answer, knowing that the truth he claims will shape the sentence that follows.
It says, and it is further presented in and to said court that before the commission of the offense alleged above, and when they say offense alleged above, they mean what you're here for now, on the 16th day of July 80, 2010, and cause number 2006 CR 9302 in Bexar County, Texas, the defendant was convicted of the felony of possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams. So is that true? Were you previously convicted of that felony?
Yes, ma'am.
So do you plead true to that?
Well, yeah, that I wasn't, yeah, that I went to prison for that, yes.
All right, so is it true or not true?
True.
Okay. State any evidence to support the defendant's plea.
Yes, Your Honor, State Exhibit number 1 with all its attachments.
Any objection?
No objections, Your Honor.
The past steps forward like an uninvited witness. A felony conviction from years ago, possession with intent to deliver, laid out in exacting detail. The judge asks, and Richard admits it's true. The state moves to cement this into the record, no objections raised. The enhancement is no longer an allegation, it's a fact. And with that, the sentence's foundation grows heavier.
Mr. Ramos, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand?
Yes, ma'am.
Did you understand that today the state is going to be presenting their evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty.
That a final form is presented, the waiver and consent to stipulations. By signing, Richard agrees to let police reports and witness statements stand as the evidence, without a single live testimony. The rights to challenge and confront are once again laid aside. The judge accepts the exhibits, and with them, enough to find him guilty. The verdict is not shouted. It's delivered quietly, but the sound of it lands like a closing door.
The court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon State's Exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Respectfully, Your Honor, we ask the court to follow the plea bargain that Mr. Ramos has entered into with the state of Texas.
All right, Mr. Ramos, it appears that you were having a bad day.
Yes, ma'am.
All right, do you have any mental health issues,
I don't know.
prior drug issues?
I had an evaluation for DWI.
Okay. All right. The court will follow your agreement. The court will sentence you to 7 years in the prison, give you credit for any time served, take in consideration 2023 CR 6039 and County Court Cause number 712653.
The judge's words are steady, but the meaning is unshakable. Guilty, with the enhancement found true. 7 years in prison, credit for time served. Richard's lawyer speaks of respect for the court, but the reality is unyielding. The judge asks about his past, drug use, mental health, and receives fragments of answers. This is sentencing, not negotiation, and the agreement will be honored. The gavel hasn't yet fallen, but the path forward is now all but fixed.
Counsel, is there anything else with regards to sentencing?
Your Honor.
All right, Mr. Ramos, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Ramos, do you have any family in Bear County?
Ma'am.
Do you have any family here?
Yes, yes.
Do you have a support system?
Yeah.
All right,
So yes,
Yes, ma'am. Yes, ma'am.
thank you, counsel.
With the sentence set, the court turns to final matters. Richard is reminded that because of the plea bargain, he has no right to appeal. He is told of the lifetime consequence, never again allowed to possess weapons or ammunition. Questions about his family and support system follow, but the moment is less about connection and more about closure. The law has spoken, but one last warning still waits to be given.
So when you get out of prison, you need to make some changes, because otherwise, if you pick up a new offense, your attorney, I'm sure, has probably told you this. I know he probably did. You will be listed as a habitual.
I
And
did
if-
tell you that, didn't I?
And if you're listed as a habitual and you pick up a felony, depending on the felony it is, your minimum sentence would be 25 years. How old are you?
34.
All right, at some point, you're going to get to the point where I am, which is I'm in the twilight of my life. You only have about 20 more years before you're in the twilight of your life. Don't let the majority of your time have been spent in prison. You understand? All right, good luck to you.
All right, thank you.
Good luck,
You're
Mr.
welcome.
Ramos.
Thank you. Have a good one.
You too.
The judge leans in with a message that cuts deeper than the sentence itself. Change your path, or your future will be lost to a cycle that never ends. Another felony could mean a minimum of 25 years, time that would take him from youth to the twilight of life inside prison walls. Richard is 34. The window is closing. The gavel's final echo is not just a legal ending, but a plea for a different life. For those watching, it's a reminder: freedom is fragile, and the choices we make can lock or unlock every door ahead.